in Dallas, Texas is now in session. Justice Peterson presiding.
I want to thank the parties. Can everybody hear me?
Yes, sir.
Okay, very good. Okay, well, I'll call the case. It's 0519-00850 CV, American Honda Motor Company Incorporated versus Sarah Milburn et al. Both sides present and ready?
Yes, Your Honor. Bill Boyce on behalf of Appellant Honda.
Excellent.
And Jeff
Excellent.
Levinger
Okay.
for Jeff Levinger for Appellee.
Yes, sir. And I'm sure y'all are familiar with our timing structure. One of the pictures that you see is a timer: 20 minutes for appellant, 20 minutes for appellee, 5 minutes for appellant. If it's yellow, you're running low on time. If it's red, please finish your thought or finish responding to any question from any of the members of the panel. But otherwise, wrap it up as quickly as you can. And if Mr. Boyce, you're the appellant, you may proceed whenever you're prepared.
Thank you, Your Honor, and may it please the court. Sarah Milburn was injured because her Uber driver was speeding and ran a red light. The judgment resulting from this Uber-caused accident should be reversed for 3 reasons. First, the trial court prevented the jury from considering Uber's conduct by erroneously granting summary judgment and preventing submission of Uber in a comparative responsibility question. Second, the judgment contravenes Chapter 82's presumption of no liability on Honda's part based upon Honda's undisputed compliance with federal safety regulations. And third, the jury was subjected to an avalanche of inadmissible and unreliable expert testimony. This included testimony from human factors expert Jo Ellen Gill, who relied on lawyer-concocted exercises as a basis for her opinions, which she acknowledged were contrived, that the exercises were contrived, and she said, "I would not call what we did scientific." For these reasons, the judgment should be reversed and rendered, or at a minimum, remanded for a new trial. And I'd like to begin with the Uber issue. I know it's a remand point and it's a little bit out of order, but I think I can present it very compactly and answer any questions the court may have. I'll devote a couple of minutes to this because the failure to submit Uber and the granting of a pretrial summary judgment to preclude evidence relating to Uber plainly contravenes Chapter 33. Chapter 33 requires submission of a settling person, and Uber indisputably was a settling person. It paid $10 million in connection with the settlement of this case. And as soon as that happened, Uber was dismissed by the plaintiff, and Honda asserted its rights under Chapter 33 based on precisely the same claims that the plaintiff had asserted: negligent entrustment, negligent hiring, negligent training. The basis for excluding the Uber from the comparative submission was the Dallas Court of Appeals opinion in Roselle, but Roselle is distinguishable in important respects. Most importantly, Roselle involved a stipulated employer-employee relationship and a stipulation that the driver at issue was acting in the course and scope of that employment. That placed Roselle squarely in a situation involving purely vicarious liability. The situation here is different because Uber's position, according to its corporate representative, is that drivers are not Uber employees. According to Uber, they are independent contractors. I would refer the court to the oral argument exhibit that was submitted on Friday. It contains pertinent excerpts from the Uber corporate rep's deposition, and it's stated unequivocally there, according to Uber, the drivers are not employees of Uber.
What was the employer in Roselle a settling party?
No, there's no indication that it was a settling party. It was the dispute in Roselle involved the plaintiff's effort to get the bus company submitted in addition to the driver himself.
Okay.
And so that is an additional basis for distinguishing Roselle. And I think it's important to focus on what we're asking for and what we're not asking for. What we're asking for is compliance with the unambiguous terms of Chapter 33, which requires submission of settling persons. The whole discussion of derivative liability is something of a gloss on statutory language, because the statute doesn't reference derivative liability. It references settling person, and that's what Uber was and should have been submitted. This is not a pro-plaintiff or a pro-defendant rule. Depending on the circumstances of a particular case, one side or the other may or may not want an additional party submitted as a settling party or as a responsible third party. The point is that the statute requires submission, and there is no basis, certainly under Roselle, to justify not submitting Uber in this case. And there's no need to back away from Roselle in any respect, because Roselle is distinguishable. The basis for excluding Uber in this case by way of a pretrial summary judgment and excluding not just submission in the charge, but all evidence was primarily a legal argument. In fact, with respect to the negligent entrustment, negligent hiring, and negligent training bases for liability, the appellee made solely a legal argument under Roselle. It was not incumbent on Honda to proffer any evidence, but there is abundant evidence in this record. Again, it's contained in oral argument exhibit 1 that's been presented to you that shows the failure to train, the failure to monitor, the failure to perform a background check that would have revealed a prior speeding violation before this accident. Bottom line, Uber committed independent tortious conduct. It should have been submitted under the unambiguous terms of the statute. The failure to do so was error, and it infected the rest of the trial because the jury was deprived of evidence relating to Uber's conduct so that it could weigh that evidence in relation to the evidence in the conduct of Honda, of the plaintiff, and of the driver, Yusuf Zai. Turning to the second issue, I'd like to focus next on Chapter 82 and the presumption that forecloses liability based upon undisputed compliance with federal safety standards. The jury found in question 1B that Honda's seatbelt design complies with safety standards that govern the risk at issue. That evidence is overwhelming in support of a yes answer to question 1B. The jury also answered in response to question 1C that the standards were inadequate to protect the public at large from an unreasonable risk of harm. And I'm going to focus on that aspect of the jury charge at the outset, because again, it's undisputed. The federal standards apply, particularly 208 pertaining to the restraint system performance requirements, 209 and 210. Expert testimony is required to address the adequacy of these standards to protect the public at large. I don't think that there's serious dispute about that among the parties. This is a situation outside the ordinary experience and knowledge of jurors. If the question on the table is going to be whether the resources of federal government having been brought to bear on a particular issue and having produced a particular safety rule, is that rule inadequate? The important point here is that the Appellee's seatbelt expert, Mr. Meyer, never said that the standards are inadequate to protect the public at large. And the Appellee does not contend that he testified that the standards are inadequate to protect the public at large. And that alone should be sufficient to demonstrate that the answer to question number 1C is supported by no evidence. It is not enough for seatbelt experts such as Meyer to say that in his preference, he thinks that an all belts to seat configuration is a better configuration here. That alone does not establish inadequacy as to the public at large. And it's important to focus on really what's at issue here. I want to emphasize the public at large aspect of this inquiry, because demonstrating that there was an accident, that there was an injury to one person in one circumstance does not demonstrate inadequacy as to the public at large. If that were the rule, then the presumption would be a nullity, because anytime there was a finding of product defect, the presumption would be overcome. But here the situation involves evidence demonstrating the adequacy of the safety standard. 800,000 vehicles sold between 2011 and 2017 with this seatbelt configuration. No complaints about the belt configuration, no suits, no recalls, no investigations. At trial, there was some discussion on the plaintiff's part that these were mere minimum standards, but that is not a basis for saying that they are inadequate. Minimum is a legal concept. It's the requirement that has to be satisfied before the car can be sold legally in the United States, but it does not address the substance or the safety of the standards themselves. And importantly, for both this issue and for the anticipated contention by the plaintiff that this safety standard does not govern the risk at issue, NHTSA specifically looked at the alternative that the Appellee advocates, an all belts to seat configuration instead of a dual detachability configuration. If you look at oral argument exhibit 3, you'll see the excerpts from Meyer's testimony where he goes through NHTSA's very conscious consideration of precisely the different design that is being advocated by the Appellee. And the federal government said, we decline to pursue this alternative for a variety of reasons. But the main point here is that all of these considerations were weighed, and the federal government expressly allows the dual detachable design that is used on the third row center seat for the Honda Odyssey minivan. That's reflected not only in oral exhibit 3, but also the excerpts from standard 208 that appear in oral argument exhibit number 2.
Is there any evidence or suggestion in the record that the seatbelt system would have failed had the shoulder strap been attached as it was supposed to be?
No evidence with respect to likely failure. There was sled testing that was done and other testing that was done, but that really went more to the whether or not there would be marks shown on the belt if it had been engaged and the accident occurred as the evidence indicated it did. What the evidence does show is, again, that there have been no claims with respect to this seatbelt design, no recalls, no investigations. And I think that undisputed evidence, combined with the absence of any evidence by the seatbelt expert that the standard is inadequate to protect the public at large, is dispositive of this issue and demonstrates that the answer to question number 1C cannot stand. And I'd like to highlight one point briefly before I move on to the next issue, which is there's been a lot of discussion of the Kia case in the briefing. I would direct the court to the portion of Kia that appears at page 874 of that opinion, in which Kia says that the Chapter 82 presumption would have applied in that case if the plaintiffs were contending that the vehicle lacked additional occupant restraint equipment, such as a third airbag in that case, that the 208 standard does not require. That is precisely the circumstance we're in. The Appellee is contending that there should be additional all belts to seat configuration used here. The federal government and the safety standards expressly considered that, expressly rejected it, and that is why Kia supports our position and demonstrates that there's no basis for overcoming the presumption. With the remaining time I have, I'd like to turn to the negligent design findings and the issues there. There's really 3 areas of focus here. I'm going to use the time here to talk about the design defect and, time permitting, the safer and feasible alternative design issues. With respect to design defect, that comes down to the testimony of human factors expert Joellen Gill that I mentioned in the opening. I'll leave it to the court's reading of the briefs on the qualifications. I will note that there is no human factors exception to Rule 702's requirements for experts to be qualified. No support for that whatsoever, but I'll leave that issue and focus on what I think is a real explanation, in addition to the Uber issue, about why this case went off the rails at trial. And why it went off the rails at trial is because Gill incorporated into her testimony evidence pertaining to lawyer-conducted, lawyer-dreamed-up exercises purporting to show consumer confusion in the use of the belt. These appear in the record at PX11 and PX12. The appellee submitted a supplemental letter brief with some links on Friday that contained some excerpts from PX11 and PX12. I would encourage the court to study those, because what the court is going to see when it looks at those is the basis why these were not admissible and why they cannot be an appropriate basis for Gill's testimony regarding a purported human factors design flaw in the seatbelt system based on consumer expectancy. What the court will see when it studies those videos is a pretty consistent pattern of questions being asked, not by lawyers. This is not by lawyers. This is not being conducted by experts in any way. Filming the test subjects, some of whom are looking at the camera and aware of it, followed up by leading questions. Were you confused by that seatbelt? Why were you confused by that seatbelt? What could be done to make that seatbelt less confusing to you? Questions along those lines that demonstrate this is not a scientifically valid study. And the court doesn't need to take my word for it, because Gill herself said, I wouldn't call what we did scientific. This study was not peer reviewed. There was no consistent protocol or methodology, and it just cannot be the basis for permissible expert testimony. And the appellee doesn't even really attempt to defend these lawyer-conducted exercises against a Daubert-Robinson challenge. There's some effort to argue that Daubert-Robinson doesn't apply. I don't think that withstands scrutiny. The court will see when it reads, for example, the Sears-Roebuck versus Coons case, that this is testimony of the specialized nature to which the Daubert-Robinson standards apply, and this does not even come close. If these lawyer-created exercises are put to one side, then there's really nothing else left to prop up Jo Ellen Gill's testimony. She makes conclusory assertions that the seatbelt design was defective from a human factors standpoint. But what she really talks about, again, putting aside the inadmissible lawyer exercises, what she really talks about are what she perceives to be deficiencies in the warnings. The warnings communicate inconsistent information. There's not enough of them. They're not prominent enough, so on and so forth. This stuff of a warnings claim, a merchantability claim, that the appellee consciously decided not to submit to the jury. There's only one basis for liability in this charge that the judgment is based on. It is a design defect claim. It is not a marketing defect or a warranty claim. And because of this, it cannot serve as the basis for supporting a design defect claim to say that the warning should have been better. And this is not just an omission from the jury charge. This is the appellee consciously on the record saying, I am not pursuing a marketing defect claim. That appears at volume 15 of the reporter's record, page 95.
Mr. Boyce?
Yes.
Are you familiar with any case where Robinson was applied to an expert's testimony where they relied on an experiment like this?
Yes, that would be the Sears versus Coons case that I referenced earlier. Again, the notion that there's somehow a litigation experiment or litigation example or trial experiment kind of opportunity that falls outside Robinson. I think the Coons case demonstrates that that's not viable under Texas law. It purports to be specialized knowledge. It is presented to the jury as specialized knowledge, and because of that, it needs to satisfy the Robinson-Daubert standards, and this plainly does not. With the remaining time that I have, I'd like to focus on the alternative design point. And I think the main point to focus on here is that the court will not see testimony that explains how the all belts to seat configuration can be used with a stowaway seat that folds completely into the floor of the vehicle. What the court will see, specifically at pages 42 through 50 of volume 13, is Meyer's testimony in which he says in a fairly conclusory and breezy fashion, oh, sure, you can use this with a stowaway seat, no problem. We're engineers, that's what we do. But when the court drills down into that testimony, what the court will see is that the folding seats that are being referenced as part of an example of what could be done are folding seats that fold in half but remain in the passenger compartment. They are not seats that fold all the way completely away like the Honda Magic seat. And that's why at page 227, volume 13 of the record, Mr. Meyer had to acknowledge that he could not identify any vehicle on the road that used ABTS on a seat that fully stows away. And
Thank you very much.
Used up my time.
Yes, sir. Thank you, Mr. Boyce. We'll come back to you in just a few.
Thank you.
Mr. Whenever you're prepared, you may proceed.
Thank you, Your Honor. Jeff Levinger for Appellee, Sarah Milburn. I think Honda is ignoring one important and I think unusual aspect of this case, and that is the extraordinary attention and diligence and skill that Judge Parker brought to this case from start to finish, especially with respect to the rulings that they're challenging. Now, I'm not saying that that insulates Judge Parker's rulings from appellate review, but I am saying that it's a very important lens through which to review all of her rulings, because she heard them multiple times, considered them multiple times, and ruled on them multiple times with considerable skill. With that, I'll start with their statutory presumption argument, and then once I talk about that, I'll turn to the Uber argument. Simply put, the statutory presumption does not apply because there's no evidence of any federal safety standard that governs the product risk that allegedly caused the harm. The key in this case, just like it was in Kia versus Ruiz, is to properly identify the product risk alleged to cause the harm. You have to focus on the plaintiff's allegations. Indeed, that's the statutory language. So in the Kia case, the defendant said, well, the product risk is the risk of occupant injury in a crash. And the Supreme Court said, no, that's not the product risk. The product risk is the risk of injury due to the non-deployment, the reliable non-deployment of the airbag in a frontal collision. And the court held there's no standard that governs the risk of non-deployment because every standard that's out there presumes proper deployment. That's exactly what we have in this particular case. Now, Honda, in their reply brief, finally identifies what they say the product risk is for the first time. They say the product risk is the dual detachability feature. Well, that's not the product risk. That's the product design. It may be one component of the product defect, but it's not the product risk. And here's the very important point. The product risk, and we've said it consistently from start to finish, is the risk of injury due to the failure of owners or drivers or passengers to reliably use the detachable seatbelt system in the correct manner as a result of the detachable seatbelt system's confusing and unconventional design. That's what the product risk is. And when you frame it that way, you see that there is no standard governing that product risk of incorrect use. The standards, again, presume proper use. Maybe another way to put it is this: the standards govern what equipment is used and maybe the performance of that equipment, but the standards do not govern whether the equipment is usable. And that's the key. That's the key distinction we need to look at. Usability.
Didn't the agency specifically look at the potential for consumer misuse and factor that into its decision making?
No, Justice Whitehill. If you're referring to the Federal Register, what the agency was looking at was a different type of misuse, different risk of misuse arising involving a different product. And in fact, you can see that in the questions of their counsel to our expert at volume 13, page 214. The Federal Register was a response to Anton's law, which addressed type 1 systems in which which allowed the lap belts to be used separately and independently from the shoulder belt. And it was resulting in a product risk where people were simply using the lap belts. And that was a real problem. And the Federal Register came into place, and it required the shoulder belt and lap belts to be integrated in a type 2 system, and it permitted detachability. But here's the important point. It did not consider, it didn't measure, it didn't analyze, and it didn't govern the different product risk arising from this detachable system. It didn't analyze the risk that drivers and owners would not reattach the anchor to the seat when the seat was raised into its upright position.
Didn't they talk about the key and how the key would make a difference in the safety?
They did, but the key to that is, again, it presumes proper attachment. It presumes that the owner or the driver attached it into the seat. They never tested. They never analyzed whether and how reliably owners and drivers would actually do that. And we know that they don't. Nor did they analyze or measure or test whether passengers, when confronted with an unattached belt, would know how to put it on correctly. Indeed, we know that the propensity of the users is to act like it's a conventional seatbelt and pull it across your shoulder and fasten it, which of course leaves your lap unexposed. So it's those things that the Federal Register did not address at all, did not address that risk. I think it's very important to look at what both sides experts said on the topic, and they agreed. They agreed that no standard governs the risk of misuse. We had our expert, Mr. Meyer, at volume 14, page 90. He said that there's no standard governing the risk of misuse or non-use from this detachable seatbelt system. Then, importantly, you have their expert, Mr. Klima, at volume 16, pages 157 to 58. And he admitted there's no regulation that analyzes the risk that people won't understand how to use this seatbelt. He agreed with our expert that there's no regulation that governs the product risk that governs the harm. So I guess I just circle back to Klima every step of the way. He said there's nothing in the regulations that analyze the risk that people won't understand how to use this detachable seatbelt system. And when I say people, I mean the owners, the drivers who don't attach it properly, and the passengers who don't know how to use it when it's not attached properly. Now, with respect to the inadequacy issue, question 1C, you don't need to reach that question because I believe you'll find no evidence to support the jury's answer to question 1B, which I think Judge Parker concluded at the end. But if you do reach question 1C, you will find ample evidence to support the jury's finding that the regulations are inadequate to protect the public from the unreasonable risk of danger. No expert had to say, gosh, I find that these regulations are inadequate. That's just a conclusion. But instead, you have testimony from Gill, Meyer, and again, their expert Klima about inadequacy. And Judge Parker, I think it's important, noted some of her findings in that regard at volume 20, pages 22 to 24, post-verdict. Now, Meyer began by describing how the old standard was inadequate, leading to the enactment of Anton's law and then the revision of the standard. But the evidence supports a finding that the revised standard was also inadequate because what it did was it introduced into the product a new and different risk. Klima, again, admitted that the regulations don't analyze usability of the detachable seatbelt system, but instead just leave it to the manufacturers. Again, volume 16, page 157. And I think that underscores on its face the inadequacy of the federal regulation because they don't require manufacturers to test or measure whether owners or drivers reliably will pull it down and reattach the belt into the anchor when the seat is moved into its upright position. They don't require manufacturers to test whether passengers like Sarah know how to use the belt or even find it for that matter when it's not in its attached position. And that's a big risk. It's an unreasonable risk because we know leaving it to the manufacturers didn't do the job. Manufacturers don't test for usability. Honda certainly didn't test. They admitted that. And we know the consequences of that. We know that people don't reliably use this seatbelt system in a correct manner when the belt is retracted up into the ceilings. Gil testified to that, and the usability studies, which I encourage the court to look at, absolutely underscore. And that's why it's a danger to the public at large, not just to Sarah, but the public at large. The fact that they claim you don't have complaints, we don't know that that's true. People may complain to the dealers and rather than to Honda. We just don't know what that means. And it certainly, while it may be some evidence, it doesn't overweigh or overwhelm the other evidence here of the inadequacy of the standard. And then to top it off, Meyer also testified about how, and again, relying on the Federal Register, how manufacturers had prevailed upon the government, NHTSA, to allow for detachability because of the cost savings. There's like a $15 savings per seat. And the jury was entitled to find that the standards were inadequate for that additional reason, because they allowed the manufacturers to simply elect cost savings over what's obviously a safer system, which I'll talk about in a moment. Going to the Uber entities, this is one where Judge Parker got it absolutely correct in ruling that the Uber entities cannot be included in a proportionate responsibility question, both because of the law and because of the absence of evidence. The fact that they're a settling party is insufficient in and of itself. There also has to be evidence, and there has to be law to support the submission of a settling party, or any party for that matter. Roselle absolutely controls this case. It's not limited to the employer-employee situation. In fact, that's why the opinion uses the words owner/employer, because you don't need an employer to have negligent entrustment, hiring, supervision, and training. And it's not just Roselle. We have Roselle. We have many other cases cited in our brief. We have the excellent Baylor Law Review article from Professors Underwood and Morrison, which we quote in the brief on page 57, that makes, I think, a couple very important fundamental points. That responsibility.
What was the employer a settling party in Roselle?
It was a defendant.
But was it a settling party?
No, it was a live defendant in the case. So it was submitted in the liability question. And then the issue is whether it should have been submitted in the proportional responsibility question. The court held no, because the theories were both vicarious and derivative, and any liability of the driver would just be passed on to the defendant. So for that reason, the court held that it was proper not to submit them in the proportional responsibility question. And the reason, of course, is pretty obvious. Responsibility can be apportioned only among those who were directly responsible, who were directly involved in the accident. Responsibility cannot be apportioned among those whose liability depends upon or is derivative of the conduct of the person directly involved in the accident. That's just black letter law. And that's certainly the case here with every theory they concocted against the Uber entities. None of those theories were independently actionable against the Uber entities unless and until Yusufzai, the driver, committed a tort. Every theory was dependent. And that's especially true, I think, of the fraud and negligent misrepresentation theories. They're also derivative, because anything that was allegedly said by the Uber entities cannot be false. It cannot have caused any harm unless Yusufzai was actually driving unsafely and caused the accident. And on top of that, I think Judge Parker also properly found there's no evidence of fraud or negligent misrepresentation. There was no evidence of any statement that Sarah heard, saw, or relied upon. Any statements, as opposed to the accident itself, were not the cause of any kind of damages. It was the accident that caused the damages, obviously, not any kind of alleged statement. And then they were unable to even pinpoint who amongst these multiple Uber entities supposedly made any statement. Uber Technologies, all they do is license the app to riders. Razier, all they do is license the app to the drivers. And then Uber USA, they can never say what it did at all. So for all those reasons, legal and lack of evidence, Judge Parker got that one exactly right in not submitting the Uber entities and allowing them to just clutter up the record with irrelevant
Let's deal with Caterpillar. Let's deal with Caterpillar and the notion of balancing utility and things like that.
Right.
let's assume hypothetically that an argument is made that Caterpillar is distinguishable because you're dealing with a big piece of equipment and you've got this big ROP on top and it has limited uses. And that's a different category of utility as opposed to this little utility of being able to have a flush floor. Does that make a difference under Caterpillar?
Justice Whitehall, I think you're talking about safer alternative design. That's really what the Caterpillar case involved. What the Caterpillar case said was that when you substantially impair the product's utility by requiring some safer alternative design, then it doesn't count as a safer alternative design. And in that case, essentially the safer alternative design was to permanently affix a top. And the court said that would substantially impair the use of this device, this machine, because it was made to go in tight spaces. And for that reason, you had to have the option to take the top off. I think the example it gave that was so good was you can add 2 wheels and a cab to a motorcycle, but then it's no longer a motorcycle. You've substantially impaired the product's utility. Basically, the test is, are you destroying or eliminating the product's utility? Now, importantly here, Meyer, our expert, offered 2 different safer alternative designs. I think counsel sort of glossed over the 2 distinctions. One is all belt to seat with the stowaway seat, the so-called magic seat. The only issue there they raise is that economically and technologically feasible? Well, yes, it is. I mean, Meyer described how easy it is to simply move the bolt from the ceiling onto the top of the seat and strengthen the seat. And then at that point, he said, yes, it will still fold into the floorboard because it's just a packaging issue. And importantly, the case law says that the design, it doesn't have to be built, it doesn't have to be tested, and it doesn't even have to be in production to count as a safer alternative design. The other safer alternative design he offered was, again, all belts to seat, but this time with a fold down seat. The seat just folds down on itself. They admit that's feasible. Indeed, their own Honda Insight has that exact feature, but this is the one where they claim, well, it substantially impairs it. But the evidence showed the opposite. It doesn't substantially impair the product's utility. In fact, both parties' experts, Meyer and Klima, said, the Odyssey can still haul people. It can still haul cargo. The fact that there's a fold-down seat, yes, it may mean that you don't have quite the same amount of cubic space available for cargo. But both Meyer and Klima said that basically what we're talking about is a few additional sheets of 4x8 plywood, and no one could identify anyone who buys the Odyssey for the purpose of transporting a few more sheets of additional plywood. So coming back to the Caterpillar case, this is not a case of substantial impairment of the product's utility for purposes of the safer alternative design. It doesn't destroy it. It doesn't eliminate. It can still be used as a Honda Odyssey hauling people and hauling cargo. Maybe not quite as much, but that's not substantial impairment. And importantly, it's a fact issue, as Judge Parker recognized, I think, during the Daubert hearings, that the jury was entitled to credit. I want to talk about their attacks on Gill, the human factors expert. Again, this is one where Judge Parker was absolutely correct in exercising her discretion to admit Gill's testimony over their challenges to her qualifications. She's a highly qualified safety engineer with expertise in human factors, which is simply the study of the interaction between humans and any kind of machine or equipment or product. You don't need to be a specialist in any kind of equipment or machine or product, as she very carefully explained in the Daubert proceedings. And in fact, as Judge Parker pointed out, there's nothing unusual or exotic about seatbelts. She said that's something that every adult uses every day in the course of rejecting Honda's challenge to qualifications. Now, Gill's testimony, I think as I explained in the brief, did not need the usability studies at all. She said that. She said my study is based upon my experience, my training, my skill, and the application to principles of foreseeable human behaviors and consumer expectancy. Now, she said, and I'll come to the usability studies in a moment, but basically she offered essentially 5 different opinions based on human expectancy and based on foreseeable human behavior. She talked about how owners and drivers are unlikely to reliably attach the belt when the seat is into its upright position, largely because of Honda's inconsistent and unclear and obscure instructions. Now, counsel said that this isn't a marketing case. Well, that's certainly true. But one of the key factors in determining unreasonable danger under the Genie case and under the Tempte case is the adequacy of warnings. That's factor 4, and consumer expectations. That's factor 5. So that's highly relevant to unreasonable danger. She talked about how passengers are unlikely to know how to use the seatbelt correctly. They treat it like it's a conventional 3-point system, where the first thing you do is you reach and pull it across your shoulder, which of course leaves your lap dangerously unattached. She talked about how Honda failed to do any kind of testing or analysis to mitigate this hazard or risk of harm. They just made these untested assumptions about human behavior. And then finally, she talked about how Sarah exhibited foreseeable behavior in, first of all, she was lucky to even find the seatbelt in the ceiling, but when she did, she pulled it across her body and latched it like anybody else would. Finally, the usability studies. Judge Parker absolutely correctly exercised her broad discretion in admitting those usability studies. I do want the court to see those, because you'll see that they meet the test of Williams out of the Supreme Court and Cox out of the Dallas Court of Appeals in showing substantial similarity.
Mr. Levenger, did Honda's counsel have an opportunity to question the expert over the differences between the circumstances of the experiment and the accident itself?
Yes, they questioned Gill about that both pre-trial and raised that in the Daubert, and then questioned her about that at trial. And then they even put on their own expert who testified about the differences. But the jury was entitled to find, and I think Judge Parker was correct in recognizing that the differences were not material. If anything, the differences favored Honda by making it easier to attach because of the lighted conditions and so forth that Sarah didn't face. Finally, I would just point out that the Kunze case that counsel mentioned is the exact opposite of what we had here, because there the trial court excluded the study, and all the Court of Appeals held was that the trial court did not abuse its discretion in using the Robinson factors. That court and no other court has held that the Robinson factors must be used with these usability type studies. Indeed, Williams and Cox, which are good laws, say that you don't.
Thank you, Mr. Levenger.
I think my time is up, so I'll thank you very much.
Thank you. Justice Boyce, whenever you're prepared.
Thank you, Your Honor. I'm going to address a couple of points quickly and then return to the Uber point. I would ask the court to focus on the language that was submitted in question 1A. It conforms to PJC 71.4. No reference in there to warnings. Discussions in a summary judgment context from Tempte or other circumstances involving warnings is really not governing here in terms of the evidentiary review. That's governed by the charge as submitted. With respect to the alternative design, I would encourage the court to read volume 13 of the reporter's record, page 42 through 50, Myers' testimony. I don't think the court will see there any testimony that the stowaway seat will still fold all the way into the floor if ABTS is used. It's simply not there. To address Justice Whitehill's question with respect to Caterpillar, I don't think that the utility standard turns on whether it's a big device or a small device. I think the logic of Caterpillar applies with full force here, because the logic that the plaintiff used in Caterpillar was to say, even if you require a front-end loader to have an unremovable canopy, you can still use it for a lot of things that front-end loaders are used for. And the court solidly rejected that consideration, because it said, just because you can still use it for most things doesn't mean that you can necessarily say that the utility is not impaired. And that is the circumstance here. Couple that with the testimony, the lack of testimony about an ABTS system being able to fold all the way into the floor, and I think you'll see that it's on all fours with Caterpillar. I'd like to return to the Uber point here briefly. And I want to be clear about what our burden was in responding to this summary judgment, because it was a little bit blurred in the presentation of opposing counsel. With respect to negligent hiring, negligent entrustment, and training, there was no contention raised in the plaintiff's motion for summary judgment that there was a lack of evidence on those issues. The sole and only basis for seeking summary judgment was Roselle. And as we discussed already, Roselle is significantly distinguishable in multiple respects. And so I think everything the court needs to see the error in the Uber summary judgment is attached to oral argument exhibit number 1. That is the Uber corporate rep's deposition. We've highlighted the parts that show that this was not an employment situation. Uber emphatically denies that it was an employment situation. And that takes us out of the Roselle scenario right there. I also want to focus on the fact that this contention somehow that these were throwaway claims does not withstand scrutiny on this record. These are the same claims that the plaintiff herself asserted against Uber, and these are the same claims that Uber paid $10 million to settle. I don't think Uber paid $10 million to settle claims for which there was no possible evidence. And this notion that somehow you can only submit people who are, quote, directly involved in the accident, close quote. I've looked at Chapter 33 real hard. I do not see that statement anywhere in Chapter 33. The unambiguous terms of Chapter 33 mandate the submission of settling persons, and Uber certainly was one. With the remaining time I have, I want to focus on the question of whether the 208 standard governs the risk at issue here. Again, everything this court needs to answer that question is contained in Oral Exhibit 2 and Oral Exhibit 3. 208 is Oral Exhibit 2. Myers' testimony about it in the federal rules is in Oral Exhibit 3. 208 did not cover just one narrow kind of misuse. It addressed multiple kinds of misuse. As Justice Whitehill referenced, inadvertent detachment of the second attachment point. That's why there's the requirement of a key or a key-like device. It addressed misuse in the terms of incomplete attachment of the belt. And I think what the court will see is that there is abundant evidence to support the jury's yes answer that the standard governed it. This is on all fours with the Wright case, because the government standard expressly considered the alternative that is being advocated, ABTS, and said, no, we think that is suboptimal for this kind of seat. Again, established in Oral Exhibit 3, Oral Argument Exhibit 3. I see I've run over my time. Thank you.
Thank you so much. We really appreciate the part. Excellent briefing and excellent argument. I think you're really going to help us try to make the right decision on this case, and the case is
submitted. Thank you all.
Thank you.